All right, guys, if I'm coming to you from my home office, you know what happened. There's been a huge case that has come out of the Federal Sixth Circuit Court of Appeals. We're talking machine guns, we're talking bump stocks, we're talking pistol braces. Yes, this is all going to fit together. I'm going to break this case down so it's really simple. And guys, the same arguments that the court used here to reach the decision, striking down the ATS rule, all map very nicely to also striking down the pistol brace rule. We're going to get through this case really quickly. So guys, here we go. So this case was argued back on January 19th of 2023, decided today, April 25th, 2023, coming out of the Sixth Circuit. That's Kentucky. So we're talking about specifically machine gun. When is something a machine gun? Or specifically, I guess, when are bump stocks machine guns? Are they ever machine guns? And really what we're talking about here, and I'll link I'll copy paste the statutory definition, what is a machine gun, in the description box below, so I don't have to hit you with it. But we're talking about specifically this part of it. This is when a machine gun is a machine gun. It's a weapon which shoots or is designed to shoot automatically more than one shot without manual reloading by a single function of a trigger. When a bump stock fires, is that a single function of the trigger, or is it repeatedly functioning the trigger every single time? The answer to that question may actually determine the outcome of this case. And of course, for those of you who don't know, yes, the ATF waffled on this, but believe me, we're going to be getting into that. So the court starts out by observing the fact, and oh, by the way, little teaser, the court lays a smackdown on the ATF. A spicy one. And I will get to that. They do it sort of at the end. Yeah, teaser, but you're going to want to hang around for this. Just trust me, okay? Okay, so the court basically starts out by saying, look, this isn't so simple. This isn't so straightforward. There's actually been 22 court opinions spanning multiple different cases across at least 4 different circuits. The 10th, the 5th, the 6th, as well as the DC Circuit, interpreting whether or not the ATF strike down of the bump stock, or rather attempts to strike down the ATF's ban on the bump stock, should be legal for various different reasons. 22 different opinions on this, okay, spanning multiple different lawsuits. Because keep in mind, you can get more than one opinion per lawsuit. If judges rule 7-1, you could have all 6 or all 7 on one side agreeing. The one who dissents, that could be 2 opinions. Or maybe 3 judges on the affirming it side or on the winning side of that outcome may write 3 different opinions or something like that. So you can have all sorts of different outcomes on that, okay? But here, right now, as far as people upholding the ATF ban, we got the 10th Circuit and the DC Circuit. This is the scoreboard. As far as circuits that have struck down the ATF bump stock ban, we've got the 5th. The 6th Circuit, which is where we're talking about here, actually tied 8-8 among the judges when this came up. And that's going to be important because the very first question the court's going to get to is whether or not this statute is ambiguous. And you guys, you're going to see how all 3 of these plot points connect and also how it's going to map out to pistol braces. Because keep in mind, if the statute is unambiguous that bump stocks are indeed a machine gun, then pretty much game over if you're pro bump stocks, okay? Pretty much game over if you're pro ATF. It's game over if the statute is unambiguous. But the court says, look, we've got 22 opinions, almost 350 pages of ink spilled across numerous legal decisions, basically saying yes or no on this point. Can't be too ambiguous, right? And the court says we're not going to go into it all in all that much detail because lots of other courts have done that. But the court also notes something else that's really interesting. ATF, you're claiming this is such an unambiguous statute. You guys made the exact opposite ruling for over a decade. Over a decade. But now you're saying it's so unambiguous. It's so clear. How could you reasonably reach another outcome? Well, you did. For a decade, that would be like a 5th grader, right? Because I think 5th grade, 10-year-olds, something like that. I'm sure someone will correct me in the comment section, but you get it. And the court takes them to task on that. And they say, well, you've had more than one reasonable interpretation of the statute. So look, number one, different courts, as well as you guys, the ATF, have reached multiple conclusions on this. The statute's ambiguous. So then we get into the Chevron doctrine, which you've heard people bandy about online. If you haven't, this is going to be really important. When Congress passes a law, they don't fill in every single possible issue that the law could apply to. And as a result, different government agencies, in this case the ATF, but it could be the Environmental Protection Agency, it could be the IRS, it could be whoever. It's their job, part of their job, is to not only enforce those laws, but also to make reasonable and permissible interpretations, provided they're not arbitrary and capricious, as well as the fact that it doesn't go against the plain meaning of the statute, and of course the statute needs to be ambiguous enough for whatever particular question you're answering. So basically, government agencies get to color in the lines, but if the line doesn't connect here and there, they can't just like jump out. They need to connect it like that. Sure, there won't be any memes made about me doing that or anything like that, right? So that's in essence what the Supreme Court said in a case called Chevron, which comes from 1984. And that's where we get the Chevron doctrine, which says, look, if something's ambiguous, the government agencies that are tasked to interpret these and enforce these particular codes and rules, these guys are the guys who can make a reasonable call. And the court says, yeah, not this time. And they say it for a couple of reasons. Number one, they point out the fact that, look, the government didn't even argue for Chevron. The ATF got so cocky, or maybe they're just negligent in court, I don't know, but they got so cocky, they didn't even argue Chevron. And the plaintiff, Hardin, says, yeah, you guys, they didn't argue Chevron. You can't bring up Chevron now. You didn't argue that. Okay, all right. But just the same. And by the way, the ATF said, quote, it is unnecessary to consider what level of deference, if any, the rule should be accorded, end quote, because they felt it was so unambiguous. The same rule that they flip-flopped on. By the way, flip-flop, not my words. That's the Sixth Circuit Court of Appeals words, okay? But number two, Hardin argues that, look, you really shouldn't be doing the Chevron doctrine anytime we're talking about criminal code here, because we don't want unelected bureaucrats basically deciding who gets to go to prison, what is a crime and what isn't. That really feels like something we should elect people for. And the legislature certainly is far more, elected than, I don't know, Steve Dettelbeck or insert interim ATF director or something like that here, right? Hardin's words in essence, not mine. But you kind of get the point here, all right? So, and the court basically says, yeah, kind of, but they point out that virtually every federal code and statute out there has usually some sort of criminal tooth behind it, right? So it may be predominantly civil in scope. Do your business, you can't do this, or this may happen. But if you push the rule far enough, there's usually some sort of criminal provision to it. But the court says Chevron doesn't apply here. Maybe not only because the fact that the government ATF didn't argue it, but they kind of set that argument to the side. They mainly go into the fact of, look, the machine gun statute is a predominantly criminal statute, but also this. I'm going to read. Second, we perceive of no special expertise possessed by the ATF with respect to the construction of the statutory scheme that the judiciary lacks, end quote. That's code for ATF. We can read this every bit as well as you can. You're not special, ATF. Not my words, Sixth Circuit. Don't look at me. That's what the Sixth Circuit said. We perceive a no special expertise possessed by the ATF with respect to the construction of the statutory scheme. And it makes sense because a lot of judges come from criminal backgrounds and so forth, and basically interpreting criminal code is not some sort of arcane procedure like going through securities laws or occupational safety laws where judges are going to get lost very quickly and yeah, we're going to leave it to these guys. But that's not the case here. The judges say, look, this is very much inside our wheelhouse and the ATF has no special expertise. Guys, no Chevron here. Yeah, that was kind of fun to read. So the third thing, so if you're keeping track, we've got number one, the statute's ambiguous. Number two, no particular deference, no Chevron deference to the ATF on this particular issue. And here we go with number three, rule of lenity, lenity. This is such an important common law concept that unfortunately we see trial courts all over the country kind of forget. And the concept is this. These are the headwaters of it. The concept is this. One of the surest ways to get to tyranny is you have a government that passes ambiguous laws and then they interpret them however they want to put good people in jail. We don't want that. You want tyranny, that's how you get tyranny. But we don't want that. And I'm not suggesting anybody is per se doing that here. I'm just explaining the rule of lenity. So the rule of lenity says, yeah, we don't want that. We don't want tyranny. So how about this, guys? If there's an ambiguous criminal statute and someone's being prosecuted for it, if it's ambiguous, then interpretation goes to the defendant, provided that it's reasonable. Don't hit me with your crackpot theories, okay? That's in essence the rule of lenity. Ambiguous statute, it's criminal, someone's being prosecuted, interpretation goes to the defendant. And that's what the court said here. That's step 3. Ambiguous, no Chevron. Because it's ambiguous and no Chevron, we now hit rule of lenity. We're done. That's it. That's what they say. That's the playbook. And that's the playbook not only here for bump stocks, as we see here in the Sixth Circuit. Does that sound like something that kind of could apply to the flip-flopping and everything else? Doesn't this seem kind of analogous to pistol braces? Kind of seems that way. And by the way, we did, if I do say so myself, a pretty darn okay video talking about whether or not the pistol brace rule is going to be struck down because of the Cargill v. Garland case, which is the Fifth Circuit when they struck down this exact same issue, the bump stock issue. So I'm going to link that in the description box below. And oh, by the way, this is not the first or second time with respect to bump stocks or pistol braces. The ATF has said, yeah, you're good to go, you're good to go, you're good to go. Nope, everything's a felony unless you turn over everything and destroy everything. Sorry, guys. We're clarifying the rule. Not the first time they did that. I actually interviewed somebody on this channel. I think I titled the video, He Got ATF'd. Kind of like that. Hopefully that takes off. He got ATF with respect to the inventor Bill Akins, who seems like a fantastic guy who invented something called the Akins Accelerator, which is kind of like a bump stock on crack. It was a predecessor to the bump stock. And the ATF basically said, you're good until you're not good, turn in everything. Yeah, good luck. Okay. So you want to see someone who got ATF'd and what it was like to be in the trenches of that fight, go check out that. I'll link that in the description box below. And oh, by the way, if you're interested in pistol braces, I happen to have had an interview with one of the lead attorneys fighting the ATF. No, it's not the case that has had the preliminary injunction ruled. Totally different case. We're waiting for a ruling on that any day. I just talked to him last week, Attorney Lucas Weber. Any day we should be getting a ruling on his preliminary injunction on that case. I'll also link that in the description box below. Guys, if you enjoyed this video, please take a moment, click like. It tells me that you got something out of this. It also tells the algorithm it's worth checking out. Of course, share it around. Let me know. Oh, and by the way, the last time I went up north to go chainsaw down a tree, they dropped a very favorable ruling. And I'm down here and doing this because I'm about to go turkey hunting up north. And I know there's some trees that came down in some late winter, early spring storms. So I'm going to be chainsawing again. I'm seeing a connection. The universe is telling me I have to chainsaw more trees because every time this happens, we get a very favorable ruling. I don't know. We'll see if this holds. All right. If you've not already done so, please consider clicking subscribe. Fantastic way to show your support for the channel. Absolutely free. And you make sure you miss no future content. As always, thank you very much. And we will see you in the next one.